Hey everyone, Dan McKenzie here with the McKenzie Law Firm. We are an estate planning, estate administration, and small business counsel law firm in the Denver area in Colorado. Wanted to make a video today talking about a concept called a trust protector, and specifically what kind of powers they have and why those powers can sometimes be so extensive. So first, before I get into that, describe what a trust protector is. And I'm standing here in front of a diagram that I made for a client earlier today talking about just estate planning generally, but specifically with regard to trusts, and just reminding you that in trusts, what a trust is, it sounds like a thing. What it actually is an agreement between three people. And that those three people are the person making the trust. I refer to that person as the trust maker, although sometimes you'll hear the terms settlor or grantor or trustor. Those are all terms for the person who is making the trust. So that is somebody who has certain property. They have opinions about how they want that property distributed. They're the ones creating the trust by writing a trust agreement containing those opinions and explaining how they want things managed. And then they take that trust agreement and they take the property that they want managed and they hand both of those over to the trustee. And the trustee is, their job is to protect that property, proactively manage it, make sure that it's being put to productive use, that it's protected. If it's a property that needs to be insured, that it's being insured. If it's a property that needs to be risk diversified, like a stock portfolio, that is happening, that we don't all have all our eggs in one basket, so to say, and that things are being done. If there's real estate, for example, again, that it's being maintained and kept up and all that kind of stuff. So that's half the job, and then the other half is just to make sure that they follow the instructions in that trust agreement that the trust maker made. So if the trust agreement says, hold this property until my kids turn 30 and then give it to them, whatever's there, at that point they have to do that, whether they agree with it, that's a good idea or not. And then the third party involved, of course, is the beneficiary. That's anybody who is entitled to receive assets from the trust. So in the example I just used, the kids who are entitled to receive money from this trust when they turn 30, those are the beneficiaries of the trust. And so different people, could hold multiple positions at the same time. That's actually very common. When you set up a revocable living trust, you're usually actually all three of those people. A lot of times when someone passes away and they had a trust, if they had more than one kid, one of those kids might be the trustee, and then all the kids are the beneficiaries, so that one kid is both trustee and beneficiary. That's very common, although very tricky, so actually that's something to be aware of. But the challenge here is that a lot of trusts become irrevocable, right? Like you have your revocable living trust, but it's revocable while you're alive. The moment you pass away, it becomes irrevocable. And then some trusts are set up to be irrevocable from the outset because people are trying to get some sort of asset protection or tax benefit. And so they got to get assets out of their estate, so they got to make the trust irrevocable to make that happen. So irrevocable is what it sounds like. It means that the trust really can't be amended anymore. It can't be revoked. And if the instructions have gotten out of date in some way, or if some problem has arisen that we hadn't anticipated when we drafted the trust agreement, a lot of things can come up. And of course, the beneficiaries and the trustee could be disagreeing with each other about what the trust instructions say and what they mean. So there's just a lot of things that can happen after a trust has gone into place and has become irrevocable that are really not desirable. So in that situation, again, the trustee's job is just to follow the instructions. They can't change them. So again, in my previous example, let's say that the trust agreement says, well, when the kids turn 30, go ahead and give them whatever assets are in this trust. But one of those kids has suffered some sort of disability incident, and now they're relying on some sort of government income that is premised on them not having a certain amount of assets, and giving them these assets would just actually go to their medical care and not actually to kind of disqualify them from receiving those benefits. So that's not good. So what if we need to change the trust to deal with a situation like that? Or what if we need somebody to come in and resolve a dispute between the parties? Well, the trustee can't do that. They usually are one of the parties in the dispute. So, they don't have that power. So in those situations, of course, people can always go to a court and ask a court to revise the trust agreement, or tell the trustee what needs to be done, or tell the beneficiaries that what they're asking for is not allowed. And that starts to look a lot like litigation in a lot of cases, and with parties all having lawyers and it getting very expensive, and there being kind of a slow process involved with hearings and rules of evidence and all that kind of stuff. So that certainly can have its place in some situations, but in general, we're creating trust because we want to keep people out of court. I mean, it's one of the primary benefits of trust is that things are handled privately, usually without any court oversight. And so what do you do to keep people out of court when they have trust? And one way to do that is to add a position to these three. And that extra position is called the trust protector. And the trust protector's job is to kind of take the place of the court, actually. So if a dispute arises, the beneficiaries or the trustee can go to this trust protector, and the trust protector is deputized to go in and do things that a court would normally do. But usually this is filled by a person like a lawyer or an accountant or some sort of professional fiduciary, somebody who has expertise in this and is not necessarily in the kind of court bureaucracy and can handle things with a little bit more flexibility, maybe a little bit more timely, maybe at a little bit less expense, and maybe the people involved in this whole thing can just come into their office and sit at a conference table and hash their things out without going through, like I say, a whole formal process if that's not really necessary. And so the trust protector has a lot of power, and so it takes a lot of explanation a lot of times in a trust agreement to explain, here's what the trust protector is, here's what their authority is, and here's where it begins, here's where it ends, and who can this person be, and how do they resign, how do they get appointed, like all those things. But the question is, like, why do they have so much power? Like when we have trust protectors in our trust agreements, sometimes clients look at it like, wow, this person has the ability to change my trust. They have the ability to tell my trustee, who I've put a lot of effort into thinking, who should this be, that they're doing something wrong, that they need to invest differently, or that they need to make different disclosures to beneficiaries. Like, I don't necessarily want my trustee subject to those kinds of instructions from someone else. The reason why the instructions are usually so expansive is just, again, because whether we put this stuff in there or not, or create this trust protector position or not, or give the trust protector these powers or not, the beneficiaries and the trustee can always go to court and ask that certain things happen. And so, you're really not preventing them from happening by not giving a trust protector those powers. You're just creating a situation, again, where there's a heightened likelihood where the parties involved are going to have to go to court. So a lot of times the powers are very extensive. We address concerns about that by making sure it's very clear that the trust protector is not one of these parties. It's not someone who has anything to gain from the trust. It's not somebody who it's really supposed to be a whole independent party that really has nothing to gain from this, a lot like a court would be, right? So we're very clear about that, and then we put a lot of instruction there saying, like, okay, yes, you can change the terms of the trust, but within these boundaries. Like, the purpose of this power is for you to be able to change the terms so that they more closely align with what the trust maker's intent was, right? So going back to my example, where a beneficiary has suffered some sort of disability or some other challenge that we had not anticipated. The purpose is not for the trust maker to swoop in and disinherit a beneficiary that they don't like, right? It's to make sure that that beneficiary who suffered this development that we hadn't anticipated still gets taken care of in a way that the trust maker would have wanted, that is consistent with their instructions. And so, it takes a lot of, like I say, a lot of explanation in there. When you're looking through this, a lot of times, again, this person does have a lot of power, and people are, sometimes are uncomfortable with the idea of someone coming in there and being able to do some of this stuff. But again, the question is, what happens if you don't give them those powers? And again, those powers are still out there. It just means that they need to be exercised by a court. And once people are in court, the chance that the combativeness or the arguing or the expenses are going to go up is probably higher, we think. Because the U.S. court system is designed to kind of make people fight. I mean, that's how it works. It's an adversarial system. So we're trying to keep people out of that process. So that is why the trust protector's powers are so extensive in a lot of cases. But it really is up to you to determine if you even want a trust protector, and if you do want a trust protector, what powers do you want to give that person? It might be some and not all. You know, it's one of the benefits of a trust is you do get to kind of make decisions about things like that, and customize it to what you're comfortable with. So if you want to have that conversation about those, a trust protector, or even whether a trust is right for you, we're happy to have that. We are the McKenzie Law Firm. We are in Denver, Colorado. Our phone number is 303-578-2745, and I appreciate you watching this video. I hope it was helpful. Thank you.